because this is the whole reason that we're in this situation right now. Okay, so far you're very close to being released. You just have 2 more things to agree to, and that is L and to show up fingerprints. So let's go to L. You must comply with the following conditions. Not to post anything verbally or in writing on any social media platform or any electronic mailing or discussion sites containing the name or inferring the name of Justice Thomas McEwen or any similar name. Within 72 hours, remove all references, verbally or in writing, posted by you on any social media platform or any electronic mailing or discussion sites containing the name or inferring the name of Justice Thomas McEwen or any similar name. Nothing prohibits you from referring to Justice Thomas McEwen in any communication to an official, bona fide investigative body, tribunal, or enforcement agency. In other words, don't post anything on social media about Justice McEwen or using his name. So that's what I'm telling you. And you're saying under the Human Rights Code you cannot be punished. Okay, whatever you're holding up is fine, but you have to agree to this release. Okay, so if you don't agree to that, that is the whole crux of this matter, right? Show it to him. He's got a volume on. So,
okay, but
are you agreeing to these conditions?
But
you can go online.
I'm just asking you a question. You first of all have never given me any notice of that ever, other than today. I've seen this, right? And because you understand why I'm saying this, because you understand those circumstances, you understand why, you know what I'm saying? You're violating, right? That's all I'm saying.
I'm not violating anything. I'm trying to protect a complainant who doesn't want his name blasted all over social media. So if you want to say, I'm Mr. Sword and I'm a victim of a judge or something, that's fine. Just don't use his name. If you want to use his name to go and report him officially to the Ontario Human Rights Code or something like that, or an official body that investigates judges, or if you want to report him, send an online message to the police reporting him in private, that's fine.
But I'm saying this is violating this.
Okay, it's not, right? But for now, you can agree to this condition and leave, and then take it up with the Crown on your first appearance, or you can take it up with the Crown, you can go before your first appearance. But as far as I know, that it says you cannot be punished or threatened with punishment for speaking out or being harassed or discriminated against. Okay, I'm not doing that. I'm telling you not to keep saying...
No, but that's what I've been speaking out against, and it pertains to what he did to me.
Okay, just don't use his name. Just don't use his name. Because look where it's got you.
No, but you never...
Okay, so you're not going to agree to that.
Let me ask you a question. You've never told me this before today, and you've just gone ahead and arrested me without ever giving me a caution with this. All you've ever said is don't contact indirect and direct up until today, right?
Sure
now, not with this.
Okay, all right. Well, think about it. I mean, it's.
I'm just saying, rather than you're going to an arrest without ever have given me a caution for this number L, right? You've never given me any communications to say you're not allowed to post on social media about what happened to you, where I'm talking about harassment and discrimination at the hands of him, right? And instead, you're going through to arrest me without ever giving me a caution on L.
I'm pretty sure that I sent it to you in an email.
You never gave me that. If you can you produce your email, because the only thing you've ever said to me up until today is don't contact indirect, direct, and I've abided by that. So what I'm saying is you're now going with, like, would it not have been more appropriate to say, now I don't want you posting on social, and give me a caution before going through an arrest, because you've never given me, you've never told me, you've never told
I'm
me.
not going to debate the point. Right?
No, but I'm just saying.
What I'm saying now is we're going through the release stage.
Okay.
And it's up to you whether you want
No, but what I'm saying, all I'm saying, Mr. Warren, you've never given me a caution, and if you can produce, you've never given me a caution, which is unfair to say you can't post on social media and tell about what's happened to you.
Let me just read you, if I'm assuming you're going to agree to prints, right? So let me just read this. If you flip that over to number 7, right? Read that, flip that over to item 7. It says, the conditions of this undertaking may be varied with the written consent of the prosecutor and yourself. In addition, you or the prosecutor may apply to a justice of the peace to replace this undertaking with a release order. So for tonight, if you were to agree to that condition, I'm prepared to release you, and then you, under item 7, can go and see a prosecutor and get some consent, and if you have a valid reason that you feel, and with the charges that are which will be before the court, if you feel and the Crown feels, so I didn't go to law school, I'm just a detective, right? And my job is to protect my complainant. My complainant is harassed because of this the accusations you're posting online in the public, right? So just bear with me. So he's harassed by that, right? So can you harass somebody and still be a victim? I guess you could, right?
No, but that's not, my question was, you've never given me any communications about L before coming to an arrest for me, right? It would have been more appropriate at some point before you get to the point of arrest. I mean, you can see I'm here, I'm peaceful. I'm very friendly. I was just chatting with him just in a friendly way, right?
Me too, and I'm trying to get you out the door.
So what I'm saying, would it, rather than going to an arrest, would it have not been more appropriate for you to have said, we don't want you to post on social media despite this, which you just read out, which says that, according to the Human Rights Code, that's all I'm saying. You've never, ever given me any...
That says you can't be punished for speaking out against harassment.
And discrimination, which is what I've been doing.
Yeah, that's like, as I understand that, that's like speaking out in the workplace and you're getting punished and fired for that. This has been an ongoing for a year when you've been accusing the judge.
No, if you look at section 3, if you look at section 372, for any unlawful reason, this is a lawful reason, because I'm speaking out based on being discriminated against and harassed by him, for which I reported it to the police, as you know, right? All I'm saying is, up until this point, you have never told me about this L, and I'm also advising you of this, right?
Okay, I get that. Thank you so much. Now I'm advised of that. Now, I'm pretty sure I sent it in an email, but I don't have access to my email. But having said that, we've been sitting here discussing this, and now you know what that condition L is. So you have the choice of whether you agree to it or not, knowing that number 7 says that you can apply to have it.
Is there any way you can go and get that email and give me a copy of it that you say you have?
I sent you one. I can.
No, you can print it out, because I'm not comfortable having you email me. I'd rather just, if you have a printout of what you say that you've given me that information prior to coming to the point of an arrest.
On, right? So you know that in section 7, the condition of this undertaking may be varied with the written consent of the prosecutor and yourself. Okay. Now.
No, all I'm saying is, can you give me a printout of that email that you say where we haven't had, I don't think, very many emails anyways, right? But if you can give me a copy of that printout where you've given me a caution with regards to L, right? I'm going to agree to this, right?
Okay.
But I'm telling,
and I'll give you a copy as you leave.
Okay, well, I'd like, so give me a copy where you've given me some sort of a caution with regards to L, because I know you never have.
Okay.
Right?
Yeah. Once you're released and you want to wait there, I'll go up to my office, I'll print it up and I'll give it to you. We okay with that?
Okay.
It'll be date stamped, time stamped.
All right, so you're saying that I don't have the right, which is my human right, to speak out when I'm being harassed or discriminated against.
No, what you're saying is, I don't want you to post anything verbally or in writing or any social media platform or any electronic mailing or discussion sites containing the name or inferring the name of Justice McHugh.
But that's
you can say,
that's me
I am
speaking
Mr.
out.
Sword, I have been harassed during a court process and I've reported it to X, Y, and Z. Just don't mention the judge. Because you can mention it, you don't need to put it out.
But that's the person who did it to me, and he's getting away with it because nobody's helped me.
So you're trying to punish him in the media?
No, I'm not trying. No, I'm not.
You can say what you like, you just don't mention his name. You can say, I've been going through a court process and the judge has been harassing me, has been doing this to me and doing that. Just don't mention his name.
Okay, so you don't understand that that's against my human rights.
You can protest.
I'm just asking, you don't understand that, you're saying that you don't understand that that's against you're violating my human rights by punishing me. You're punishing me.
I'm trying to let you go. I'm trying to let you go. Never wanted to detain you.
Okay, so you don't, all I'm saying is you don't understand that that's against my human rights for you to prevent, you're punishing me now.
I'm not punishing you. I'm trying to let you go.
No, but you're punishing me by arresting me without giving me a caution ever before this, telling me that I'm not allowed to exercise my human rights to speak out on social media or in any public forum to say, this guy did this to me.
Yes, you can. You can say, this guy, this judge, but just don't mention his name because that harasses that judge. Because he's not been convicted, he's being tried in the media, and you are putting his name out there to the public. You have options to complain about him through judicial bodies, human rights bodies, police bodies, but you're not. You're putting his name now out in public on all kinds of social media, and I've seen them myself, and so that's harassing communication, directly or indirectly, and he doesn't want it anymore. It's gone into the criminal, it's gone criminal now, and so to protect my complainant, you complain. No one's going to punish you for saying that, hey, I've been sexually abused. Just say that. Don't mention his name. Go to the Human Rights Code. You can mention his name because there's a clause there that you can go to any official body.
But then I'm not.
You just want to send it out to millions of people.
No. As a woman who's been abused for the past 2 years by this, But anyway.
Okay, so if you don't want to agree, I can't make you agree. I can't make you agree. If you don't want to, you don't want to.
No. I you know what? I'm going to agree because I'm forced
so
right
if
here.
You're going to agree,
I'm forced today to agree to this only because I need to be released. Right? I'm forced to be agree to this, although I know it's against my human rights.
And you know that you can go and see a Crown Attorney, and if they agree that it's against your human rights, then they will change it.
Okay, and I also have indicated to you that you've never all you said is indirectly, directly, and I abided by that. I'm only now being told about this section L, where
you wouldn't have shown up if I'd have told you is what you said.
No, I didn't say that. I said I'm only now being advised about this. Don't twist my words. I'm only now being advised about this. I've never been given a caution about this, and yet you're going into arrest without ever giving me a caution on that.
So, L, yes or no? Are you agreeing to that, to get released? Yes or no?
Although I know you're violating my human rights, I have to agree because I can't get released otherwise.
Okay, all right, so it's a yes then. Okay, that's fair enough. That's fair enough, because I don't want to keep you here. I don't want you in the station anymore. I want you released to be able to speak to lawyers and to go to court and to get your life moving without putting this guy's name in public. So that's passed now. L is good. Now, number 6. You are required to appear on the 25th of May 2023 between 9 a.m. and 9 p.m. at 52 Division 255 Dundas Street West in Toronto for the purpose of identification of Criminals Act. Do you agree to item 6?
What is that?
You've got to get photographed and fingerprinted for a criminal offence. Do you agree to that? You have to come back on the 25th of May between 9 a.m. and 9 p.m.
Yeah. Okay, and again, I'm asking you since you never cautioned me with regards to L, why are you moving to an arrest as opposed to giving me a caution and allowing me an opportunity to rectify it and then, take it up with the public body to say that, because I'm going to put in a complaint on you because you're I feel it, I feel you're, yeah, right? But I'm saying you've never, ever.
You want to move on?
Yeah, so I'm just asking you.
Can I get you out the door?
But can I ask you, why have you never given me this information before going to an arrest?
Can we move on?
So you're refusing to answer that?
I told you already. I sent it in an email.
You did not.
Okay, well then I have to check my emails then.
Okay, so you'll give me a copy of that before I
I
leave.
can give you a copy, yeah.
Thank you.
You're going to get full disclosure.
No, but you said before I leave today, you're going to give me a copy of that. You're going to go upstairs and print it
You
out.
want to wait for me to go and find an email?
Sure.
I have no problem.
Sure. There haven't been a lot between us.
Number 7. The conditions of this undertaking may be varied with the written consent of the prosecutor and yourself. In addition, you or the prosecutor may apply to a justice of the peace to replace this undertaking with a release order under section 515 of the criminal code. Okay, so that is just letting you know that as much as you hate L, right, you can get out the door and you can speak to a prosecutor, and if the prosecutor is in agreement with you, they can vary it and you can go before a justice of the peace and you get a separate release. This will be null and void and you'll get a release that is negotiated with you and the crown. So this could only last for tonight or a day or two. Right? This is just to protect my complainant, who I will, and then this will get you out the door. The mandatory, this is number 8 now, the mandatory condition and the conditions indicated by a check mark on this undertaking remain in effect until they are cancelled or changed, or until you have been discharged, sentenced, or otherwise detained by the courts. And this is section 763 and 764 of the criminal code. Number 9 is important. It says here, you are warned that unless you have a lawful excuse, you commit an offence under section 145 of the criminal code if you fail to follow any of the conditions set out in this undertaking, including to fail to attend court as required, to fail to appear as required for the purpose of identification of criminals, and to fail to remain in the territorial jurisdiction specified in section 5 of this undertaking. I don't think we mentioned number 5, because I never asked that you had to stay here. I don't want to limit your mobility rights, but if you don't show up for court, they can issue a warrant. Pretty much now it's all Zoom. I'm going to give you Zoom instructions. Also, if you do communicate with Justice McEwen, or you go to his house or his work, or you post anything after tonight, you could be arrested and charged. If you get it buried, you get it buried. That's not my business, that's yours and the Crown's business, okay?
Will you give me information on how to get a hold of the Crown?
I'm going to give you the sheet of your first appearance and all the instructions that you're entitled to. So if you committed an offence under 145 of the criminal code, a warrant for arrest may be issued. It's not a lawful excuse to an offence under section 145.4 of the criminal code that this undertaking does not accurately describe the offence that you are alleged to have committed. This one does. If you do not comply with this undertaking or are charged with committing an indictable offence after you have been released, this undertaking may be cancelled and as a result you may be detained in custody. This is a release document, and technically if you commit an offence while on a release, you could not get another piece of paper, not another chance to walk out with a piece of paper. You could be technically held in custody. That's what this piece of paper is saying. Okay? If you do not comply with this undertaking, the funds, you can read this, well, I'm not asking for any funds.
What funds?
Funds, money.
Oh.
We're not asking for funds. It says if you do not comply with this undertaking, the funds or valuable security promised or deposited by you, that's usually for people out of province. They pledge money or property to say they'll come back to face court. It's not applying to you. This is a generic form for all kinds of crimes and for all kinds of people wherever they live in Canada. So we're moving to number 10. Okay, so I understand the contents of this undertaking and agree to comply with the mandatory conditions and the conditions that are indicated by a checkmark. I understand that I do not have to accept the conditions, and that if I do not accept the conditions, I will be brought to a justice for a bail hearing. Okay. So do you understand that? Number 10.
Mm-hmm.
Okay, so at this time, do you agree to all the items with a check mark, that you will comply, you will go to court, you will show up the fingerprints, and you will abide by all the conditions with a check mark? Do you agree to this document?
Mm-hmm.
Yes?
Mm-hmm.
You're making noises. I have to record it in case there's a breach. Or do you agree to go to court, to show up the fingerprints, and agree to the conditions?
Yes.
Thank you. That's all it is. So I will give this one to you. If you could sign there, that's the signature of accused, and I will sign here as the. And if you want, I will sign your one. And if you want, you can make sure that what you're signing is exactly the same as this. I have no qualms about that. Or you can sign both and choose one for yourself. But I printed this up from the same document, so I just printed ×2. So if you want to sign that, you're officially released. You can choose whichever one you want. So now, how to contact and connect. So this is the instructions. So let me just 20, so that's 2020. Okay, so now under the under Canada Evidence Act, I'm just going to give you a notice, and I'll just sign this. Can choose one of those, and you can sign them if you want, choose whichever. And what this is just your written notice that for your trial, going to be bringing documents as listed, right? That'll be transcripts and emails that you've sent to Justice McEwen. That'll be copies of any writings that you've posted online, so stuff like that. And you are free to go at 8:20.
Okay, so when will you be giving me these disclosures?
Hmm?
Will you be giving me a copy of all these disclosures?
Usually, your first appearance is in 6 weeks, and you notice I changed the date to accommodate your birthday, right?
Yeah.
So, because I'm a nice guy, right?
I know it's that.
So, choose one of those yourself,
Okay.
right? So,
What is this?
Hmm?
What is this?
That's your Canada Evidence Act notice that documents are going to be used at your trial.
Okay, so now you're going to get that email from me.
I'm going to look for it, yeah, and I'll bring it down.
All right, and then when am I going to get all the disclosures that you say you have?
It starts off like I had to get some disclosure to you, like by your first appearance date you should have some disclosure, right? And then there's always ongoing disclosure requests. But then once you have it all, you can then discuss with the Crown how you are willing to...
And these transcripts, are they going to be transcripts of the court proceedings?
Pardon me?
The transcripts that you're talking about here, are these of the court proceedings that, like with the audio? What happened to the audios? Because why aren't you including audios from the hearings?
I don't have audios, and that's not a document.
I know, but why would you not be, are you not going to be ordering the audios which will prove all of my allegations as to why?
No. You're released now, right? You know you're released. You can leave, right? You can leave, but if you want to, you can leave. You're released, right?
But I'm saying when...
If you want to have a discussion, I don't mind.
No,
I'm still recording it. I'll have a discussion. I don't mind.
No, I'm just saying, Okay, are you going to just get the email? Because we've talked about the audios of the hearings. Are you ever going to get those?
I don't believe so, no, because I don't need to prove your allegation to prove that the judge is harassed. Just by you making the allegations over and over in a public forum and to his workplace and to all his co-workers, that's enough to harass him. I don't need to actually prove I mean, I've never been tasked by my supervisor to investigate the judge. I've never been. Right?
So you're not investigating the whole story. But anyways, can you just get the email because I want to go?
You can have a look for it, but you're free to go.
Okay.
Now,
so you promised that you were going to go get it. So we don't have to have any more of a discussion. Yeah. If you can get me the email, then we're done.
These ladies are not under arrest. They're released. And I just don't want you wandering around.
No, I'm just waiting for the email. I'm going to wait right here for the email, and then we're going.
Okay, good. Okay, all right, let me go.
You promised to get me the email. You said you'd be able to print it out. We haven't had too many communications, so it should be easy, right?
Yeah, for sure.
Okay.
It'll be the email that I sent you to surrender yourself.
The email that you say says that you gave me a caution about L. Okay, thank you. Thank you. You just turn it off? You look familiar. I don't know why, but you look familiar.
I was at your door.
Oh.
I was up there with Ward, Detective Ward, and the other officers.
Last week?
Yeah, was it Thursday, day one? Around the
Oh.
last day.
Were you the one with the sunglasses?
That's me!
Oh my, okay, because you look different without the sunglasses. Very different.
In a mask.
Yeah.
Yeah.
Oh, okay. Huh. Hey, look at him. You look so familiar. Okay. Huh.
Yeah, I looked up at the camera and I could see the little blue light going. So I figured it's probably motion activated and recording.
Oh, okay. Yeah, because I noticed you looking at it all the time. So when I came home and stuff. So.
Are they hardwired or is it wireless?
The moment that you notice you being recorded, yeah. Those are wireless, actually.
Wireless? Was it through like a home security or your own?
No, I just got my own. Yeah, because the home, you gotta pay even $25. It's like you can get all the cameras for like I think I got them on sale for like $300 at Amazon, and then I got 5 of them all around the house, and then you can see them on your phone, everything, and then every 2 years, it's even actually 3 years, you just change the batteries.
I was going to say, how long is the battery? So 3 years?
Yeah,
That's pretty good.
they say 2 years,
Even in
but
the winter, with the cold.
yeah, they say 2 years, but
Yeah.
it's like I found that they've lasted 3 years. Like I only changed the front and the garage one once, and then the other ones they seem to still, because it's not they're only going to be used as soon as you're getting
Right.
and typically you turn them off when you're home, and people, I just pretty much put them on for when I leave or at night. Yeah, just so I feel kind of safe, because before like these days, this especially Brampton's has gotten with home invasions
Has
and
anyone ever stolen the camera?
what, stolen it?
Stolen the camera?
No.
That's what I always wonder about, right? You have them there, and if they're accessible, someone can jump up and grab them. Are they like,
But then you know what?
they're hardwired?
If-
But
if-
like even like the camera, is it like a wire through?
Well, mine, I don't know, I could be sitting here and I have a little bell that will go off.
Yeah, yeah.
So as soon as somebody comes to my driveway, before they even reach the camera, it tells me. And the same with my doorbell,
Well, what happens with that is if somebody were to reach up, because it's on my cell phone, it would record them stealing it.
It'd be stupid.
So it'd be stupid
Unless they were
because-
all masked or something.
Yeah, because and to do all that, it's like you're going to be recorded, and then it goes straight to the police, right? So, so I don't like now. It's like it's nice because even if you're getting a delivery from Amazon, you don't have to hang around, because if anybody steals it, I know exactly who stole it, right? So it's just nice for just convenience, you know.
Yeah.
And then you never have to you never have to worry about salespeople and stuff because you can know who to answer the door and stuff too, right?
The doorbell is really good.
Like a ring?
Yeah, I've had that forever, and it's like the most amazing. I think, it shows everything. You can have a speaker where you
You can
can
talk to
speak
the
to them
person,
right by.
from like anywhere in the world.
Yeah, yeah. And then you can, I don't know if that's a good thing or not, but sometimes, like, if the kids are at school
Yeah.
and they didn't bring their key or they forgot the punch code, you can open it with the ring. They just put the phone to it and it'll tap the phone number, right?
Handy. Technology.
I know, but I'm actually not impressed because I find like I prefer the good old days. You can walk really
Yeah.
like videoing
Yeah.
you or recording you or you're not out there like even with like cars you can't even drive. I mean, say it's safety for one, but it's the kids are out. These perverts are sitting and cracking.
Yeah. Yeah, there's a lot, and I think because we grew up in Ottawa, and I mean, you could leave your doors open. Like, I mean, it's not here. I just find that people are very, I don't know. I just
Not when you first came. Just
No,
a
it-
couple of years.
it's just gotten really. I find I find it even in Ottawa because when I lived there, I remember I had a boyfriend there, and he was don't come to Toronto because they're not, and he was right. Like, I mean, I just find the caliber is different because there everybody either works for Bell or the government or they're lawyers, and it's just you don't have all the crime, and it's just people are so like people at stoplights and stuff, they'll let you in, and they'll say good day. You can walk down the streets, everybody's saying good day to each other, and it's a different environment. Like here, it's like people are pretty much push you over to
Everywhere is
no, but
Brampton's gotten bad now. Brampton's gotten bad now. It wasn't bad before. It's just really gotten bad now.
Yeah, it's because it was the cheapest area in the greater, because I'm a realtor, it was the cheapest area in the whole of GTA. So a lot of people from, I guess, what would be considered, I won't name any of them because I don't want to be generalizing, but the rougher areas, a lot of people from those rougher areas moved up there because they're, lower income and stuff. And then, I don't know, it just seems to be a lot of drugs. And one of my customers says that because he leaves in the wee hours, that he's even seen prostitutes. And it's just a lot of they never used to be panhandlers. Now you stop at the stop sign, like the stoplight and stuff, and there's a ton of panhandlers. And you go to the grocery store, and it's like, you feel scared because it's like you go to do your grocery, these people are hanging around, and who knows if you open up, or they're coming up to you in the car, and you're like, it's just weird because you used to see it in Toronto, but never up there, right?
Jack, did I turn my camera off? Let me turn it back on.
Yeah, turn it on.
Yeah, yours is easier.
Made for us.
Okay, so this is the email I'm referring to. It's from Paul Ward, sent Wednesday, April 12th, 2023 at 4:15 to mohinipersaud@bell.net, and it's CC to my supervisors, Inspector DeCosta and Detective Sergeant Higo, and it's in regards to police occurrence 22-235-7473. Recipients, my supervisors, there's 2 blanks because they were also sent out to other people. You don't need to know who they are. So I just blanked them out, right? So I'll read it to you.
But that's
I'll read it to you.
okay.
Hello, Miss Persaud. I have received an update in the criminal complaint about you from Judge McEwen via the Justice Sector Security Office, JSSO, at the Ministry of the Attorney General. Basically, the judge wants you charged now with harassing communication under Criminal Code Section 372. I have recently reviewed many online posts and videos where you specifically name the judge. In January, you were sent the following: please do not communicate in any way, directly or indirectly, in person or by any means, electronic or otherwise, with Judge Thomas McEwen, or you will be charged. do not communicate anything by any means, electronic or otherwise, about Judge Thomas McEwen, or you will be charged. Brackets. This does not prohibit you from filing complaints with any bona fide body, agency, or tribunal. No one's wanted to stop you filing a complaint with a proper body that can investigate it for you and give you the closure you're looking for. Now, I'll continue. You are now requested to surrender a 52 division to be arrested and released on an undertaking with conditions. You will be given a court and fingerprint date, and if you agree to the conditions, including no contact, directly or indirectly, with Justice McEwen, and not to go near where he lives, works, and frequents. Also, not to post anything verbally or in writing on any social media platform or any electronic mailing or discussion sites containing the name of or inferring the name of Justice Thomas McEwen or any similar name. Remove all references, verbally or in writing, posted by you on any social media platform or any electronic mailing or discussion sites containing the name of or inferring the name of Justice Thomas McEwen or any similar name. Nothing prohibits you from referring to Justice Thomas McEwen in any private communication to an official bona fide investigative body, tribunal, or enforcement agency. If you agree to the conditions, you will be released and on your way. I will give you a week to absorb the facts that you are now going to be arrested and charged, and that you consult with counsel. Upon surrender, you will be advised of your rights to counsel, that you have the right to retain and instruct counsel without delay, and that you have the right to telephone any lawyer you wish. You also have the right to free advice from a legal aid lawyer, and that you can apply to the Ontario Legal Aid Plan for assistance. I will give you 1-800-265-0451 that will put you in contact with a legal aid lawyer for free legal advice when you come in, if you want.
Okay, so just to stop you there, what's the date of that email?
This is April 12th, 2023.
Okay, so prior to that email, you had never given me a caution or told me anything about posting on social media.
The first
Correct?
portion was that this is
Okay.
the surrender.
Okay, so
This is the surrender.
Okay, no. So what I'm saying is, this is dated April 12th.
Let me see if this runs into the one that I gave you previously.
This says no, but this says. Let me just show you. Hold on.
No, I know what it says.
Okay, but previously to this,
Which is
you had,
January 12th.
yeah. So previously to this, you had never given me a caution or told me that I am not allowed to post on social media for being harassed and discriminated by Justice McEwen. That's all I'm getting at. You've never given me a caution.
Yeah, because you hadn't.
The only time you had given me notice of that was when you actually decided to charge me. So you went straight to charging me, as opposed to saying, Mohini, we don't want you to doing this either. Like,
Okay,
you understand?
So here's the January 12th portion, right? And it goes on and on and on. The same, it says, I've reviewed, please do not communicate in any way, directly or indirectly, in person or by any means, electronic or otherwise, with Justice Thomas McEwen, or you will be charged. Do not communicate anything by any means, electronic or otherwise, about Judge Thomas McEwen, or you will be charged. This does not prohibit you from filing complaints with any bona fide body. So that's two.
Yeah, so you've never given me any information to say that any caution, again, this is confirming what I'm saying. You went straight into charging me for speaking out about what I experienced from Justice Thomas McEwen, which was harassment, discrimination. You've never, prior to April 12th, where you decided to charge me with this email, apparently advising me that you're charging me, before ever telling me that you did not want me to post on social media. I abided by what you said in January 12th, where you said do not communicate with him indirectly, directly.
In any
so
way.
I didn't do that.
In any way.
But that's not communicating with him. That's me going on social media, communicating and saying this happened to me, right? So all I'm doing is I'm confirming that you have never given me any kind of a caution to say that you felt that me speaking out for my right, where I'm being harassed and discriminated against, which I have a human right to do. You have never said that now you're going to violate my human right and say that, I can't speak. You've never given me any kind of a notice other than April 12th when you said, I'm going to charge you. because you went on social media, but you've never given me that because your January 12th indicates that you've never done that. That's all I'm saying.
Yeah, because January
Yeah.
12th, you hadn't posted it.
Well, it doesn't, but then if you've never told me, other than now you're
If you
charging
want to
me,
sit and discuss, I can.
right?
Feel free to go.
That's all I'm
not trying to
saying.
hold you. You've
So,
got your
so
email.
just to confirm,
You've never posted anything
you've never said that I couldn't do that. That's all I'm saying. You've never given me a caution. You just decide to go straight into charging me when you've never said that I cannot speak out on social media and say what this guy did to me. Okay?
Written black and white, what I said.
Yeah,
There
exactly.
you
So
go.
you've
There you go.
never told me that by speaking
You are on
out.
your way whenever you want to go.
Yeah. So anyways, I'm just confirming that.
Yeah, you've got the email.
Yep, exactly. I've got the email.